Welcome back to the course, Protecting the Legal Rights of Artists and Designers. I am Jonathan Politi, and we are working our way through materials covering the legal system and dispute resolution. And in this segment, we will be covering the court process and what steps are taken in pursuing a lawsuit. So in this section, we're going to be picking back up where we left off with the court process, and we're going to be dovetailing from the chutes and lawyers example that we have with those worksheets to sort of map out the process. So I have these visuals here to take a look at and use those sheets to follow along. Remember, the law is about relationships, expectations, process, and consequences. What happens in the process of a civil lawsuit? Who is involved? How are they related? What are the expectations? And what are the consequences? Here's Jimmy, the artist. And here's Top Hat Charlie. This is an old version of Stick Figure Justice that I have revived for you. So the legal process is a process for resolving disputes. You were supposed to paint my portrait. I'm suing you. You never paid me. I'm suing you back. This might be a good point for you to take out the worksheets, the flowchart that I gave to you for chutes and lawyers. Use this as a map. So you have a complaint, you've got a counterclaim, you've got accusations on both sides. Charlie sues Jimmy. What are Jimmy's options? Well, there's three options. Jimmy can file a motion to dismiss. Hey, you've got the wrong person, this is the wrong court, too much time has passed. Or he could file an answer and a counterclaim. And he can do all those things at the same time, option 1 and option 2. And he also has the option to do nothing, depending on what the circumstances are. Doing nothing is doing something. Jimmy sues Charlie. What are Charlie's options? If it's a countersuit, same thing. Same options. File a motion to dismiss, file an answer, file a counterclaim, or do nothing. All of this is called the pleading stage. This is where the parties will plead their case to the court. All right, what happens next? That's it, discovery. Discovery is where they try to discover what they can about the facts. They are serving requests on one another. What are the discovery options? Ask questions. In person. That's a deposition. Under oath. Written questions. That's interrogatories. Don't confuse that with depositions. Not an interrogation. Interrogatories are written questions that are provided to be answered by the other side in writing. And ask for documents, request for documents, request for paperwork, quote unquote paperwork. Again, remember that can be electronic documents as well as physical documents and other evidence. All right. Gathering that evidence together, that has to be relevant and it has to be probative. So it can't just be open-ended. It can't just be collecting information for the sake of collecting information, or a fishing expedition is how we like to call that. See what you can reel back in. If they want to limit any types of information, or if they want to expand it, then they can have a hearing on that and they can ask the court. So, types of evidence: photos, video, audio, diagrams, chemical tests, reenactments, medical records, invoices and bills, witness testimony. Those are all different examples of the types of evidence that can be requested and collected. Maybe the case settles. All throughout the process, there's pressure from the court and there's incentives for both sides to settle the case. That can be for a number of reasons. If they are not happy with the way the case is proceeding, If they're discovering new evidence and find out perhaps they're in the wrong, if they're uncomfortable and they're not sleeping at night, or it's taking a toll on them, or it's costing more than they anticipated, those are all reasons why court cases settle early before going to trial. This is taking way too much time. This is just a misunderstanding. So maybe the parties are able to work it out. Maybe the case doesn't settle though. If that's the case, after discovery, then you go to pretrial. Remember, that's a pretrial hearing and it's preparation. So at that point, they're getting ready for the trial, which is the actual presentation. The presentation is storytelling, where both sides get to present their case to the court. So the legal process provides a process for resolving disputes. The advantages are that it is public and open, not hidden behind closed doors, so it's subject to public scrutiny. That also means that it can be observed by everyone, so your business becomes everyone's business. The process is also predictable. Expectations can be reasonable because it should be possible to predict what will happen. The big disadvantage for civil lawsuits is the cost in time and money. Many times that's time better spent somewhere else and money better invested on other ventures. And there are other options for resolving disputes that we will talk about. Administrative hearings are another way for resolving disputes. Generally, without going into great detail, government agencies have administrative hearings to resolve issues within the scope of the authority of a particular government agency, so that the subject matter jurisdiction of these administrative law hearings is limited. That's both federal and state agencies. So it could be for child support, medical eligibility determinations, environmental violations and compliance, water management, violation of motor vehicle rules, construction regulations, insurance licensing, and liquor licenses. It's often as a result of an investigation by the government agency. Parties can request an administrative hearing to resolve issues, and many of the processes and procedures are similar to traditional courtrooms, but each agency will be different and not as formal as a court. The process for that particular agency should be looked at. Best practice is to check with the agency or with an attorney. An administrative law judge presides over the hearing and acts as the sole trier of fact. There's no jury. A similar process of storytelling and presentation of facts, evidence, and arguments happens in these hearings. If there is a ruling of final order from an administrative hearing that a party does not agree with, it can be appealed to the courts for review, but the hearing will be treated as the court of original jurisdiction, and review will be to confirm that proper process was followed. If you want to get a little more information regarding how administrative agencies work, PBS has a good series online at YouTube called Crash Course with snackable videos that are quick-paced and informative. And the University of Washington has a good explainer video that's available as well. That brings us to the lesson of the piñata and back to the honest conversation. Normally, I use this in class and there's an actual piñata involved, along with candy and lots of commotion and lots of sugar. This is going to be another lesson that I brought back to you from Stick Figure Justice. And it's about asking what is important to you. Have the honest conversation. Is it worth it to you? Time, energy, and effort? What resources will be diverted? Will you get peace of mind? Even under perfect circumstances, will that be enough? And is court or an administrative hearing the best path to resolve the matter? Can it be worked out some other way? Why the piñata? Lots of people who want to sue think that the other party has lots of resources and assets, that they have one giant piñata filled with delicious piñata candy. They want the satisfaction of taking a whack at the piñata, getting all that delicious piñata candy, And justice will never taste so sweet as you break open the piñata and make them pay. But here's the problem. Sometimes the piñata is empty. There's no candy in it. No assets to go after. No bank accounts or property that can be used to pay the debt if you get a judgment against them. They're judgment proof. And worse, you have a piñata too. They can sue you. Counterclaims or countersuits. What is the other side going to say? What's their case against you? So, is it worth it? Have the honest conversation. What will the cost be? Something to think about. All right. With that, we finish court procedure and we'll move to alternative dispute resolution. We will pick back up with the next topic in the next video.